In accordance with the consensus attained at the April 21st, 2016 administrative briefing and work session, and the consistent with the Florida law, I declare good cause for a resolution 16-001 to be placed on an emergency item on this agenda for the protection of the health and safety and welfare of all Marion County Public School students. At this time, I will ask Kevin Christian, Public Relations Officer and TV Media Production Coordinator, please read for the record the resolution 16-001 in its entirety.
Sorry, Mr. James, give me just a minute. I was not prepared for that.
Kevin.
Got a hard copy. By the way, Kevin is Superman.
Nope, just doing my job. This resolution reads, whereas Marion County Public Schools acknowledges and supports the right of all students to attend schools that are safe, protective, free from violence and harassment, appropriate, and that ensure their right to privacy. Whereas the term sex is defined as a person's biological sex, either female or male, as determined at birth. Whereas there is a long-standing history in this nation and Florida public schools of restricting access to single-sex restrooms, locker rooms, and other single-sex facilities on the basis of biological sex. Whereas students have a reasonable expectation of privacy in Marion County Public Schools and all Marion County Public Schools single-sex facilities based on the federal and state constitutions and other laws. Whereas Marion County Public School students are minors in the majority who are entitled to education and care in a safe and protective environment. Whereas male and female users of Marion County Public Schools single-sex facilities reasonably expect not to be exposed to persons of the opposite sex while using those facilities. Whereas persons who are transgender, gender non-conforming, gender fluid, and or gender independent are not a protected class under federal or state law or Marion County Public School policies. Whereas neither federal nor state law prohibit Marion County Public Schools from restricting single-sex facilities to use by persons of a designated sex. Whereas some students may question their gender identities and assert they are transgender, gender nonconforming, gender fluid, and or gender independent. Whereas Marion County Public Schools encourages all students with gender identity issues to seek support, advice, and guidance from their parents, staff, professionals, and other trusted adults. And whereas the School Board of Marion County, Florida now desires to provide current guidance on this important, complex, and legally unsettled issue to the superintendent of schools, school principals, staff, students, and parents, particularly regarding the interpretation of applicable school board policies. Now be it therefore resolved that single-sex Marion County Public School facilities designated for girls and women, including but not limited to restrooms and locker rooms, shall be restricted to persons who are biological females. Single-sex Marion County Public Schools facilities designated for boys and men, including but not limited to restrooms and locker rooms, shall be restricted to persons who are biological males. Students wishing to use alternative Marion County Public School facilities shall always be offered comparable facilities as required by law, and students dissatisfied or having other concerns with the school district's offer of comparable facilities may avail themselves of the grievance procedures specifically established in current Marion County Public School policies. This resolution adopted this evening, the day of, you fill in the date there, at a regular meeting of the School Board of Marion County, and would be signed by the board chair, Mr. Bobby James, and Superintendent of Schools, Mr. George Tomlin.
May I have a motion and a second?
I make a motion that we vote on Resolution 16-001.
I second it.
And we have a second. As now we have discussion, and we'll start with you, Ms. Stacy, with discussion.
I believe we've discussed it a lot. The superintendent had asked us for guidance, and he had a little difficulty getting with us in guidance. We gave him guidance Thursday, and his office Thursday, last Tuesday, but tonight we're giving the superintendent written guidance with clear resolution reflecting our anti-discrimination policy that does not allow discrimination based upon sex exactly as Title IX states. We're simply making a public proclamation tonight confirming our existing policy. We are in complete compliance with Title IX as we have been for decades, thanks to our current anti-discrimination policy. We cannot help that the Department of Education, Federal Department of Education, is now working under an illegal, unadvertised rule. We believe this interpretation of Title IX has been promulgated illegally and without due process by unelected bureaucrats. It is a violation of the constitutional right to the personal privacy of our students, poses a risk to the safety of our students, and additionally will disrupt the educational process and the orderly operation of our schools. In fact, the real hoot to this entire thing is the Federal Department of Education does not even have a constitutional right to even exist. So, I would I've passed something out to my fellow school board members, and instead of reading the entire thing, it's talking about why I believe this rule is totally illegal because it has not been properly advertised by the Federal Department of Education, Civil Rights Division. I've searched everywhere. There is absolutely no advertising on this rule. But I have passed this out. I would like for it to be a part of the record so that I don't have to read the entire thing. But the school board members have had a chance to read this, so it does need to be a part of this record. Or I can read the entire thing, but it would take a while.
Okay. Ms. Ely?
I believe we've heard from a lot of parents, and I appreciate the 46 people who did speak tonight. I know it was hard for some of you to come up and speak, but it's good to hear from our public, and we wanted to hear your opinions, your feelings, either way. I believe that we spoke about this last week at great length, and I thought about something. It's that if transgenders can go into either the boy or girl bathroom, depending on their choice for the day, boys that aren't transgenders can go just to the boys' bathroom. Girls can go just to the girls' bathroom. So isn't that reverse discrimination? That's just a rhetorical question, but I just thought that was interesting. Also, the safety issue is the biggest, and although nothing has happened yet, we're going to see some things happening, folks. We will. And if, depending on the situation, we can't have teachers monitoring the bathrooms. That's not going to be possible. But if we know the rules, like we have rules in, Marion County, and kids know what they can and can't do, then they should be following the rules. And if a transgender student feels uncomfortable with the gender-neutral bathroom that's been offered to him or her, then it needs, like the resolution says, take it up with, the Marion County School Board policy. But I am definitely in favor of keeping the boys in the boys' bathroom, girls in the girls' bathroom.
Okay, I think that the school board we have the reign, respect, and dignity to a lot of people, to all of our children. When we come to school, we're here for our students. I don't think that any of us, when we're talking about school, we're talking about our children for going to school, not about what we're talking about now. I think that we could come. I just want to say, we came right here, and we did an alternate. We used an alternate for people who wanted to use another facility. I think that sometimes we talk and we think things so big, and we think we're making so big about things, when I know that everyone here, we're here for every child. That's what we're here for. The children. That's what we all think about school is about. We're not thinking about, most of us, some of the things we didn't think about, going to that when we go to a teach, that we're talking about the bathroom, that we have so much that people come together when we say, okay, well, then we realize that what we can do then is say, okay, we do have the women and we do have men, so we said we can, if you look, we're saying we're in alternate places. Because I think that we come together with our children. I think that we should think about that. We don't think about what you feel because it's your child. They're poor, you're not. You might be 12. I mean, if you're over 20 and you want to find with us about it, it feels like, oh, wait, you have to look. These are our children. And by the time they go over when they're 20, no, not one teacher in here will sit here and have the same thoughts about it, you know? And I believe that, I think, you all know, I think this really hard, and I wanted to be able to treat this. I said, well, I wanted to be able to talk, not just because I wanted to pray that it's all about God, for everybody, because I know there's every child that I, in this for, that they're here, every child may not be God. We know that. But we know when it comes for when you go to school, we hear about that for what you're, when you go to when you go to your when you go to your tab, till you go to the school, to the school place. We're here for that, you know? So I'm really, you know, I'm supporting this because I trust the children. It's what we do for them is more important than what everybody that wants to find here, or somebody wants to say this about it or whatever. It's about the children. Tomorrow for the children. You know? So that's why we came, when we came to this, I think we came because we thought about children, like again, the girls, the boys, and then we say alternate. We thought about it. We didn't come for anything but that, because so important. It's so important, I think. I say you know, I said, well, sometimes we need to just stand up and look for our children. And yes, they're going to be our mothers. Of course they're going to be father. Good job. If you're for the guard and you couldn't do it the same way that everybody thinks, still, you're doing a good through. When I go to some teachers around, one of the things I see is some of them, there's so many things. I mean, some of you have the thoughts. There's so many that comes through them. But if you look at all our teachers that come through, they're here because there's some plots that come in. You have to cry. You have to say, they really put a lot. Okay. They really come a gum thing for our children, our teachers. They're not when they come in, if you have to think, when they come in, they're not about the things. I think we're here to make sure what you come for, to be tated. That's what it's about. It's really about that. And yes, I'm saying it again, I want them to remember one more thing, for me, for God. Because if you don't believe because what I feel, I'm not going to hurt you. That's not then why would I work about the God then? Think that we're here for our children. That's all I wanted to say. Thank you.
Ms. King.
Okay, good. With my other board members, we have had a lot of discussion. We didn't come up here tonight and make this decision. Believe me, we have put a lot of thought, and we've done a lot of research also to form and come up with our opinions. And I agree with my other board members. I am also in favor of this resolution, as I believe it's important for us to respect and supply every one of our students with privacy and protection and safety of using the restroom. We're not up here trying to show, what's the word, correct word? We're not up here trying to show favoritism or discriminate. That's the word I'm looking for. Discriminate against anyone up here. But we do want to ensure student safety and privacy for the entire student body. And with this resolution, in there it states that transgender students will be accommodated with a gender-neutral restroom. if they're not comfortable attending or using the male or female bathroom that they were born to use. And if they choose, and this gender-neutral bathroom is provided and can be used by any student in the school. It's not just strictly for transgender students, it's for any student. Again, I don't feel that this is discrimination. It's allowing every student privacy and safety. And I'm just gonna leave it at that.
Okay, I'm passing the gavel to Ms. King, and I have to really just say I understand what everyone is saying, rest assured, and I hope you all will understand what I'm going to say. We are at the end of the school terms, and we have many mandates that's required to fulfill these last 5 weeks of school. Just as the nation is on stage and slowly working through the issues, we need to ensure that any resolution that we render will be passed with equality, legitimacy, feasibility, and impartiality to all of our students. This can only be done in the developing a decisive resolution that can be carried into the future and should not be hurried. We must ensure that any resolution we make does not violate the Title IX Act or law banning sexual discrimination in school. As a school district receiving title funds, we are under very strict and precise governing rules. The recent ruling from the U.S. Court of Appeals for the Fourth Circuit in Virginia marked the first time a federal court has determined that Title IX protects the right of transgender students to use sex-segregated facility that's consistent with their gender identity. This rules open the door for future rulings that could be costly to the school districts around the country who do not comply. We cannot let our motion dictate our action. I'm asking the school board to table this issue until a date, and I will give you some dates. And the reason I'm asking you all to do this is I have worked real hard with the Florida School Boards Association, and if you look at those dates, on June 8th and June 9th, we are having in Tampa this very thing that we are discussing today, June 8th and June 9th. And this will give us an opportunity to look at what is occurring in the state and throughout the country. And when I asked you to do that, I know that 4 of our members go down to there. And when we come back, we usually will say that this was a very good workshop, a very good meeting. And what I'm asking this board to do is not change your view. I don't want you to change your view. All I want us to do is to go down, look at what has been done, and come back with this. What I propose to do, and what I'm asking for us to do, is that we schedule a June 23rd workshop after you have reviewed the material that we've got from what we've got from what we get down in Tampa. When we look at what we are talking about in reference to establishing a plan, because this information is good. There is not an emergency at this point. There has been only one incident at Vanguard. And for us at this point to not take our time and look at the information that we will be getting. I listed some things that I would like for us to do in this period of time. The Florida School Board Association Summer Conference is June 8th through the 10th. That's another month. And I would like for our attorney to talk to us about the consequences of passing a resolution prior to receiving information. And when I say just look at the consequences of us and what will occur if we do not comply with these wishes. I would like the superintendent to work to develop a task force to look at how we can possibly retrofit our bathroom and take in consideration the amount of money that we will be spending if we have to defend a lawsuit, if we can use that money to retrofit our bathrooms. I would like to also have our attorney to look at a way in which we can make this thing palatable with, working with the OCR, working with the National School Board Association and their attorneys to make this work. I have set 2 dates that I feel would work for us. Once we come back from Tampa and have this information and looked at some of the schools, some of the school districts that had the same type meeting that I had tonight, and tabled it, and tabled their decision till after they came down and looked at what is going on. I will say this: Sarasota County, Brevard County, they had an opportunity to do this, and I'm asking this board not to change it. Board, I'm telling you from, as one of your colleagues, we have been very diligently going to these meetings. I can count you 1, 2, 3, 4 that go down and sit there in these meetings and go over and listen to our colleagues. And I'm urging you to, let's table this until we go down, we look at it and talk with our colleagues and come back and schedule a work session and bring these things together. And we can in turn have something in place for the beginning of our school year. I do not want to sign a resolution tonight and expect us to be enforcing it tomorrow, simply because we are rushing. And I'm asking this board to just think about what I am saying. I'm not saying anything about what all the people are saying out there. What I am saying is about what we need to do to make sure that we've covered all our bases. And it's not gonna kill us. It's not gonna kill us to wait.
Can I say something? We're gonna try, but I do think that if the state of, the state of Florida, we do, let me stop for one second, okay? I'm just trying to say that it's not so it's bad to say it. The law is the law, there's no law. Okay, for Florida, we don't have the say now, right now for that. And if you look, the Florida state, there is no law yet for it, right? So mean if the children are just other things, if you're over 20-year gays, right? One time.
Over 21 years.
For a 20 young person, what you're saying, and why I have a problem just to say it in this way, is that if you're saying that the children, these PBs, the babies, little children, they don't have the law. They're not the law. But if you're making them to be the one who have the law, but you're not having, am I right?
I understand, it's okay.
Am I right though? Yeah, I think it's just kind of,
It's okay, Angie.
Okay.
I'm sorry.
Okay,
Go to Mr. James.
I am not challenging anything that you all are saying. All I'm saying to you is that we are part of the Florida School Boards Association, and they are putting, and if you read it, they're putting on a transgender program that is talking about all the legalities of this. All I am saying to the board, there is not an emergency here. It is not an emergency here where we have to take action tonight. We can go down there and get information that other boards have worked their way through the state of Florida, and we can make sure that we are writing something that can uphold time, or it could be more in line with what we need to do, and it will be more in line with some of these school districts that have experienced this and have tabled.
Mrs. King?
Mr. Conley wants to go first, and then.
Have tabled their actions until they have had this meeting and gathered this information. I'm not asking you to change your mind. All I'm asking you to do is go down there and come back on the 21st with an opportunity to do that.
Okay, all right, thank you. Mr. Tomlin?
Thank you, Board, and I appreciate the opportunity to address you tonight. As you are aware, my personal legal counsel has reviewed the proposed resolution and has expressed several legal concerns. The substantive concerns have already been outlined to you by other attorneys, including Mr. Lake. Guidance from the Office of Civil Rights and now a federal court has indicated that this resolution may not withstand legal challenge. I do fear this will open the school board up to needless and costly litigation and have a negative impact on our students. If you as a board intend to move forward with a vote, then there are procedural requirements not currently being followed that need to be addressed. If you examine the list of the 230 or so resolutions passed by this board since 1988, you will not find one which concerns enacting a campus-wide policy or rule like this. The resolution being voted on is in fact not a resolution, but a rule, which the board is directing me to implement on all campuses. School board policy, your school board policy 2.23 and the Administrative Procedure Act set forth strict requirements on how a rule or policy is to be enacted by the board. For non-emergency rules, the board is required to provide the public proper written notice, which is advertised for 28 days prior to the vote. The notice must include a concise explanation of the proposed rule's purpose and effect, the estimate of economic impact to all affected by the rule, and the specific legal authority for the board's action. Any person who claims to be substantially affected by the rule is then permitted to file a written request with the board, seeking a determination by an administrative law judge as to the validity of the proposed action. That decision can be appealed by either party to the 5th District Court of Appeal. For emergency rules, which is how you are proceeding tonight, the 28-day waiting period can be waived, but the board must publish in writing prior to its action the specific facts and reasons for finding an immediate danger to the public health, safety, or welfare, and its reasons for concluding that the emergency vote is fair under the circumstances. An emergency rule which is adopted cannot be effective for a period longer than 90 days from the date of adoption, and it is not renewable unless the board adopts a permanent rule or policy through the normal procedures set forth by our policy and statute. If the board is intent on passing this resolution, I would urge you to follow the procedural requirements we have put in place for enacting a rule as set forth in Board Policy 2.23 and the Administrative Procedure Act in order to protect the district from a legal challenge of the process. And last but not least, I continue to believe that as educators, we should continue to try to educate ourselves about this issue and not act hastily based on fear or political expediency. School Board Policy 2.27 allows the chair of the board to appoint special committees whenever deemed necessary. This issue lends itself well to committee study and dialogue before taking any official action. A committee of persons with opposing views, willing to sit down for meaningful conversation, as well as experts in child psychology or law enforcement, would help inform and educate all of us before any permanent rule or policy or resolution on this topic is passed. Thank you.
Okay, Ms. Stacy?
Point of order. This agenda doesn't talk anything about discussing the legality of this. Our attorney responded to each one of us, and that could be included in the board, this resolution hearing or whatever. We've all seen it. Our board attorney responded to all of those things, Mr. Tomlin. This is not a rule. This is clearly guidance and a proclamation to the community as to what our policy has been, and obviously, it has withstood the test of time. It has been we have not had any violations with Title IX in 2 or 3 decades. I mean, there's just not ever been one. So therefore, I'd like to call the question, please.
I have a motion on the, go ahead.
Okay,
I'd like to call the question.
call the question.
Yes, please.
So
We are here
Okay.
to,
Point of order. Ms. Lake, I made a motion that we table this issue.
I think a sub-motion has to be ruled on first, doesn't it?
Gotta get a second first, can't even talk about it without a
If it's
second.
been second.
But I can't talk to my attorney, right? Can I talk to my attorney?
Okay.
A motion has to have a second before discussion ensues.
Right.
And
it died like a second.
Okay.
Okay.
do you want to restate your motion?
Okay.
Okay, I'm asking that we table this until we come back from the Central Florida Coalition. Until we come back from our workshop down in Tampa. I'm asking that we do give ourselves an opportunity to go down and look at what is being done. Because there is not an emergency where we have to do something and direct our people to do something tomorrow. All I'm asking is for us to table that there.
Okay. Is there a second? No, motion dies.
Motion dies. Okay, I would like to call the question, please.
Okay.
So Chairman, I'd like to call the question that we go ahead and we vote on the resolution number 16-001. This is a proclamation stating and giving guidance to our current policy that is in effect. And I'm sure that Mr. Tomlin knows it's in effect because when my students were at Forest High School, there was a child that was suspended while my kids were there for using the wrong bathroom. So the policy is the same as it was then, Mr. Tomlin, when your administration suspended a student at Forest High School that I recall for using the wrong bathroom, and it is still in place. Nothing has changed. And I call the question.
Okay.
Okay, Ms. King, would you call the question and we can vote?
Okay, I called a question.
We'll call the
Say
question.
I called a question.
Okay, all in favor? Say aye.
Resolution one.
Opposing view? Mr. James? Do you want to vote?
Wait, Did they vote?
Yes.
We voted. We're just trying to wait for it to come up.
All in favor signify by saying all opposed, say nay. I'm just putting that out there so we can hear it.
Okay. Aye?
Aye.
Yes.
Okay.
The motion passed for one